I think that the easiest antidote to the unitary executive, one that I learned from Mrs. Brundage in the 5th grade up at a public school in Lincoln, Nebraska, up the road here a ways, is basic civics. It's called the separation of powers. You all learn as kids, and it's built into our fabric of civics education as young Americans. Whether we went to law school or not, we should all be familiar with the concept of a tripartite government and separation of power. And I think that, as Sean Watts just said, it may be that there are iterations of the unitary executive theory that are indeed attractive and practically useful in some settings, and I think it is its utility or inutility in given circumstances that makes it rise or fall on its merits. One reminder about our history, I like Bob's PowerPoints. I've seen them before, and I think they're very useful, but he, like the same I would do, he picks and chooses here. He's got his friends, and he quotes them liberally. 15 minutes. Right. He did it magnificently in 15 minutes. But the Lockean history, Montesquieu, the notion of the strong executive that was so, in such a sophisticated way developed by the Europeans there and indeed embraced on this side of the Atlantic, was also reacted to quite strongly by our framers because of the abuses of the English crown. So the system we put in place was not that system, not the Lockean system, not the English system. We all learned that as kids. And indeed then, instead of exceptional, I believe that the powers given to Congress in Article 1 were, if you look at them, and as you remember from your 5th grade instruction, your teacher said, look how long that list is, children. And now compare Article 2. It's really the other way around, I believe, that the presumption is that the national security authorities are vested in the Congress, and the President's powers are exceptional. The Marbury decision, I think, is very useful point of departure in this discussion, and I think Bob Turner used good quotations there. But I'll remind you there that in recognizing situations in that case where the President would not be amenable to a lawsuit, what Chief Justice Marshall said is that the President's judgment would be conclusive. That's part of the quote that Bob had on the screen. He didn't say preclusive. If he had said preclusive, it would have pretermitted the possibility that the Congress or the courts might have been superimposed a different rule. He didn't say that. He would have left it to a political resolution. And indeed, as I teach Marbury and have for many years, it's a fitting time to raise the idea that sort of coexists with the unitary executive, what Attorney General Meese used to call properly the doctrine of coordinate construction, that it's not just the Supreme Court that decides the meaning of the Constitution, that each branch, of course, has an independent obligation to make determinations about the constitutionality of their actions. And I find nothing at all offensive about the doctrine of coordinate construction. It simply reimposes or reinforces the idea of constitutional duty. But let me read briefly the signing statement that President Bush prepared a couple of years ago in signing the Detainee Treatment Act, the so-called torture ban sponsored by Senator McCain. Here's the Bush statement. The executive branch shall construe Title 10 relating to treatment of detainees in a manner consistent with the constitutional authority of the President to supervise the unitary executive branch, and as Commander-in-Chief and consistent with the constitutional limitations on the judicial power, the executive branch shall construe Section 1005 to preclude the federal courts from exercising subject matter jurisdiction over any judicial challenge by enemy combatants, including applications for writs of habeas corpus. Now that's quite remarkable. It was to no avail, as we'll learn at a later panel, later today or tomorrow. But his insistence on the authority not only to interpret the statute, but to enforce it according to his own theory of presidential power, rather than to accede to limitations imposed by Congress or even the courts. I think, is remarkable. And to use a term that Professor Watts used a moment ago, there's a distinction between, I don't know, whatever the first term you used, and plenary powers. What does plenary mean? Without limit. There are no plenary powers in our constitutional system. Now, a couple of closing thoughts, and we have 10 minutes or so for discussion. I think that on the FISA story, Professor Turner and I differ, I think, in considerable respects. Dozens of federal courts have upheld Foreign Intelligence Surveillance Act since its enactment in 1978. It's been amended by Congress a half dozen or more times, most recently this summer, actually, to effectively authorize the previously unauthorized surveillance that the Bush administration undertook. That's a question, a set of questions for another day. But in view of the administration's activities in authorizing warrantless surveillance after September the 11th, through the assumption of authority over that program by the FISA court a couple of years ago, I believe that program was unlawful in large measure because Congress had specifically provided in the statute its intention that the mechanisms for obtaining secret surveillance be provided exclusively by the law set down by Congress. So to the extent Congress has authority in the field, and I believe it has authority in parallel with that of the President, it marked out the sphere of authority and indeed set up a very fluid and effective mechanism for executive branch assumption of secret surveillance authority. Why don't I close there and save some time for questions? Thank you.
Well done, both.